No adventitious circumstance can be equitably made a qualification for the enjoyment of political rights, such, for example, as property or the color of a man's skin. These do not confer upon their possessors either peculiarity of claim or fitness for the exercise of political rights. Property does not make a man either wiser or better, nor does the color of his skin or the shade of his complexion. An aristocracy based on the principle of education and mental superiority would be perfect wisdom in comparison of an aristocracy based on the principle of property or of color. This is so intuitively evident that I'm afraid the man who does not admit it as a first principle in the science of government is not to be convinced by argument, nor reached by any conclusion, however legitimately drawn from the principles of equity. The pretense that property gives its possessor a greater interest in the welfare of a state, and therefore a right to a greater weight and influence in the government, is too superficial to satisfy anyone, except such as are in possession of the assumed qualification, or those whose prejudices are enlisted already in its favor. In the application of a general rule, there may be exceptions, but these must not violate the principle of right upon which the rule proceeds. The exceptions should be such that while they may set aside the mere letter of the principle, are in accordance with its spirit and design. To exclude minors, for example, from the exercise of political rights is not unjust, because in the exception it is presumed, and justly too, that they are incapable of exercising these with safety to themselves or the community. So with the vicious and the criminal. Such may not be entrusted with the exercise of rights which may probably be abused to the injury of society and of themselves. The interest which a man may have in the prosperity of the state, which arises from property, dwindles into insignificance in comparison with that which is personal. Civil and political liberty and the advantages connected with these are immeasurably more valuable to a man than countless wealth, and deserve to be more jealously watched and guarded. It is impossible to establish the equity of imposing taxation upon a citizen and at the same time deny him the right of elective suffrage, thus subjecting him to the operation of laws which he has no power, directly or indirectly, of making. The fact that a man is to be made the subject of a law is a sufficient reason on grounds of equity why he should have a voice in making that law, unless he may be disqualified by vice or by incompetence. But keeping out of view such exceptions as are necessary to preserve equity and secure the objects for which civil society has been instituted, justice requires that every man should have a right to say by what laws he is to be governed, irrespective of any adventitious circumstance. Property furnishes no security to society that political rights will be properly exercised. A poor but virtuous man may take a deeper interest in the welfare of the state than his rich but wicked neighbor, and will most certainly promote its welfare incomparably more. Every man cannot have a direct voice in any of the departments of government, but he ought to have it immediately through his representatives. The principle of representation is established by God in his dealings with man. It was exemplified in the covenant of works and in the covenant of redemption. In consequence of the former, by the disobedience of one, many were made sinners. In virtue of the latter, by the obedience of one shall many be made righteous. It is exemplified also in the relation which God has established between man and woman. The head of the woman is the man. Upon this principle is the divine institution of government settled. A scriptural civil government is a representative system, alike removed on the one hand from the arbitrary rule of a despot, and on the other from the licentiousness of anarchy. The right of bearing rule over a civil society is not the patrimony of any man, nor can it be scripturally exercised by the whole community, for the institution makes a distinction between rulers and those over whom they bear, between the vicious extremes of arbitrary irresponsible power and an impracticable universal democracy is the divine principle of representation. This gives to the people the right of choosing those who shall exercise government over them. Quote, "Judges and officers shalt thou make thee in all thy gates which the Lord thy God giveth thee throughout thy tribes." Unquote. Deuteronomy 16, verse 18. In the exercise of this right, it is the duty of a government to maintain and protect its citizens, because the happiness of the community is intimately connected with the free and unfettered choice of their rulers. Thirdly, a government owes protection to the people in the enjoyment of their property. The insecurity of property in a commonwealth prevents industry, impoverishes the people, encourages idleness and crime. The moral as well as the commercial interests of the community, then, demand the most perfect security. Let property be insecure, and national happiness is at an end. Security of property includes, in the first place, that monies necessary for carrying on the government should be levied on the principle of rigid economy, that no burden should be imposed unless the safety or the welfare of the community positively demand them. Excessive taxation virtually destroys the security of private property, or the same effect may be produced by the manner in which it is exacted. If it is arbitrary and uncertain in the mode of imposition, insecurity of property will be the result. In the second place, security of property includes that citizens should be protected against unjust claims. For cases of disputed property, provision should be made for an equitable, cheap, and speedy decision. The absence of any one of these creates insecurity. If judicial decisions are not equitable, parties in such instances are defrauded under the cover of legal proceedings. If the means of obtaining justice is not cheap, it is put beyond the reach of the poor. If not speedy, it is in many cases equivalent to an absolute denial of justice. Number 3, it is the duty of a government to execute justice by punishing crime. Firstly, crime is punishable because it is injurious to society. Civil society is established to promote peace and order among its members. It has a right to make the civil constitution and laws by which it is to be governed. A right arising not merely from the voluntary assent of the parties entering into this relation, but mainly because civil government is a divine institution. Hence flows the obligation under which every national society is to make its constitution and laws in conformity to the known will of God. Constitutions of government and laws which are not in conformity to the will of God have no moral power or obligation on the conscience, because the condition upon which it has been received the authority to make these has been violated. For it will be conceded that God does not give to society a right to trample upon his own revealed will. The obligation to obedience under which the subjects of human law are is derived from its equity, or in other words, from the conformity to the will of God, for this is the rule by which its equity must be tried. This is the character of national authority. The same principle which binds the subjects of law to the duty of obedience confers upon society the right of inflicting punishment if the law is disregarded. It is a right, too, which society ought to exercise. For it is not a personal prerogative conferred upon civil rulers, with the exercise of which they may dispense according to their own pleasure. The power of punishing crime is in one sense a prerogative, in another it is a duty. It is a prerogative of society in relation to offenders, but in relation to God it is a duty which it owes him and to itself. The good of a civil community requires the punishment of crime, and this is one reason why God has given a society the right of punishing offenders. Were crimes permitted to pass with impunity, the ends for which civil society has been instituted would be lost, and society itself would soon be dissolved. Virtue must cease to be respected if vice is not punished, and in the absence of virtue, there can be neither peace nor order in society. In this imperfect world, the punishment of crime is necessary for the security and preservation of society. The punishment of crime is exemplary. One end of it is to influence society, and in the first place, it accomplishes this as a preventative. It deters the vicious by operating on their fears. The danger which accompanies indulgence in vice produces beneficial effects by often restraining from the commission of crime persons who are not under the influence of virtuous principles. The value of punishment is, in this view of it, does not depend upon the severity, but upon the certainty with which it is known to follow the violation of law. The nature and amount of punishment ought to bear an equitable relation to the character and aggravation of the crime on account of which it is inflicted. But no adaptation of this, however nicely proportioned, can operate upon vicious and unprincipled minds without the deeply impressed idea of the certainty of infliction. If, in the administration of criminal jurisprudence, the guilty frequently escape, whether this may arise from the spurious sympathy or dishonesty of jurors, the unfaithfulness of judges, or the imprudent and too frequent exercise of the pardoning power, the result will be nearly the same, and that result will uniformly be the increase of vice and crime. There is in every community vast numbers, not only of the poor, but of the wealthier classes in society, who are restrained from violating the laws merely from a sense of danger. It is the apprehension of the punishment which may follow, and not a sense of the evil of crime itself, that influence is such to avoid its indulgence. Punishment is therefore held up in terrorem for the prevent of crime, and the more certainly it is known to follow this, the more salutary will be the example. In the second place, it influences the virtuous by increasing their abhorrence of vice and encouraging them to promote the peace and order of society by a cheerful submission to its equitable arrangements. Civil rulers are a terror to evildoers and a, quote, praise to them that do well. Romans 13, verse 3. Number 2, or secondly, crime is punishable by the civil ruler because it violates the divine law. God designed by the institution of civil government to promote his own glory, as well as the good of society. He, quote, hath ordained civil magistrates to be under him over the people, for his own glory and the public good, and to this end hath armed them with the power of the sword, for the defense and encouragement of them that are good, and for the punishment of evildoers, unquote. Westminster Confession of Faith, chapter 23. This view of the end of civil government shows that crime ought to be punished not only because it is inconsistent with the public good, but also because it is opposed to the divine law. It is the duty of the civil rulers, as performing the functions of a divinely instituted office, to take care that the end for which it was instituted be secured by his administration, that the divine glory be promoted by a faithful performance of the functions of his office. A commonly received opinion is that crime is not punishable by civil rulers as immoral, but only as hurtful to society, that it ought not to be punished because it is wrong, but because of the evil effects which might follow impunity. According to this view, society has no right to inflict punishment upon the criminal otherwise than as an example, quote, that the moral guilt of an offender, unquote, is not cognizable by human authority. This political dogma, veiled though it is by the most specious pretenses, is nevertheless destructive to the ends of civil government. The glory of God is directly excluded, and the public good, the only end of society which is taken into view, cannot be obtained by a government which has no higher aim than the good of man. It is one of those false, though fascinating principles by which the infidelity of the present age is distinctly marked, the immediate object of which is to exclude God from his own works and institutions, and submit an infidel philosophy in the room of Christianity. Society, it is true, does not and cannot measure out to offenders the just retribution of moral evil, nor has God committed this to them. It is his own prerogative to visit sin with the infliction of merited punishment. Quote, for we know him that hath said, vengeance belongeth unto me, I will recompense, said the Lord. And again, the Lord will judge his people. It is a fearful thing to fall into the hands of the living God, unquote. Hebrews 10, verses 30 and 31. But while society may not and cannot punish sin properly as such, it may and ought to punish overt acts of immorality, as well because they are violations of the moral law of God, as because they are injurious to the public will. The infidel tenet, which I am now examining, assumes that society has a right to punish crime, but it places that right on the principle of expediency or propriety, that it is proper that crime should be punished, lest society may be endangered by impurity. But the reader will observe that the primary principle on which society is authorized to inflict punishment on offenders is a regard to the divine glory. The difference, and it is an essentially important one, is that the former makes the public welfare the sole principle of exercising the right of punishment, while the latter makes the glory of God the primary principle to which the welfare of society is made subordinate. The civil magistrate is, in the language of Scripture, said to be, quote, the minister of God, a revenger to execute wrath upon him that doeth evil, unquote. Romans 13, verse 4. This text proves, in the first place, that civil rulers are, in their official character, quote, ministers of God, unquote. And being such, it is their duty to serve him. But do they serve him, it is asked, when they exclude all respect to his glory in a matter of so much importance as the punishment of crime, when they exclude all respect to his law as a ground of its infliction? In the second place, it proves that something more than example is designed by the application of punishment in civil society, because the magistrate is said to be a, quote, revenger to execute wrath upon him that doeth evil, unquote. This implies that punishment is inflicted upon offenders by the civil ministers of God because of the evil which they have done, and not merely as an example.